past year, the Me Too movement has swept the country as women and men alike reckon with the prevalence of sexual assault in today's society. But the movement has also experienced significant backlash. People fear false accusations and the effects of accusations on those accused.
Could the accused have more to lose?
Right? I got boys and I got girls, and when I see what's going on right now, it's scary for all things. I mean, I wouldn't want
Who are you scared most for, your sons or your daughters?
I mean, right now, I'd say my son.
Well, I say that it's a very scary time for young men in America when you can be guilty of something that you may not be guilty of.
But sexual assault is more than just a social issue. It also presents legal problems in both the civil and criminal justice systems.
In the civil justice system, sexual assault is a battery, one of the 7 intentional torts. To qualify as battery, the defendant must commit harmful or offensive contact with another. Harmful contact impairs the body of another, and offensive contact violates the other person's reasonable sense of dignity. Most cases of sexual assault that enter the civil justice system will likely arise under the category of offensive contact. Consent is a defense to all 7 intentional torts, including battery. Consent can be either express or implied. Implied consent involves assenting to sexual behavior based on nonverbal cues. Express consent, on the other hand, is a verbal or written yes, or a clear assent to sexual behavior. Wait. What does that even mean? What exactly is consent?
Sexual consent means that both people are actively willing to engage in a particular sexual behavior and express their consent by saying, yes, that's okay with me. Anyone has the right to change their mind about what they do or do not want to do at any time. This means that even if you are engaging in sexual acts with a person and they change their mind, you must stop and respect that person's wishes.
Implied consent creates many ambiguities that have pushed people towards express, affirmative consent to make both parties' intentions as clear as possible.
Some groups have gone further than expecting just a verbal yes in sexual encounters, and instead want you to write down your sexual consent. Could you ever imagine yourself signing a contract before having sex? Probably not. But what if you just had to click yes on an app?
Sexual consent? There's an app for that.
There's a new app that may be coming to smartphones that allows you to consent to having sex before you go on the date. It's almost a legal contract.
It's called Legal Fling, and it involves a legally binding agreement before you hook up.
The most recent app, called YouConsent, offers what the developers call a digital handshake between 2 consenting sex partners before they get busy. After both download the app, one person makes a request, and the other grants it via thumbprint verification.
Think of it as a menu. This is in, that's out, this is good.
But what does it mean for someone who says no after they sign?
When 2 people use an app to consent to sex, have they made an enforceable contract? We interviewed Harvard law professor Oren Bar-Gil to find out. He explained that every enforceable contract must involve assent, meaning both parties must agree to the terms of the contract. This is where the apps come in. They establish assent by having each party to the contract click an I agree button. A contract involving an I agree button is known as a click-wrap contract, and the law has evolved to consider clicking I agree sufficient for assent. But that raises a question. Does assenting to a sexual encounter through the apps mean you aren't allowed to verbally revoke consent in the middle of a sexual encounter? There isn't yet a clear answer to this legal question, but one possibility is that the contracts on such apps may be unconscionable, which, as Professor Bar-Gil explained, means the contract is so unfair and one-sided that courts will refuse to enforce it.
So where do these apps leave us? While the legal effect of app-made sexual consent contracts may not be settled, they nonetheless reflect societal anxiety about what to do to address the widespread problem of sexual assault. Both criminal and civil law systems fail victims of sexual assault. Only 1 of every 3 cases of sexual assault are reported to police, and less than 1% end in jail time. When the criminal law system fails, many victims turn to the civil law system, where the burden of proof is lower. The civil system also fails to hold perpetrators accountable, and defendants can also bring counterclaims, filing their own suits against the victim. After-the-fact remedies and solutions are failing victims of sexual assault, and the fear of false accusations is more prevalent than ever in the wake of Kavanaugh's hearings. Legal economists suggest turning to contract law as a more efficient outcome than litigating in courts, which typically have high transaction costs. Instead of waiting for the court system to hold society accountable, might contracts have the potential to mitigate the conflict before a potential harmful outcome? In light of the widespread anxiety about what might happen in the court system, is it better to have your consent clearly written down on paper or in an app? While it might feel more efficient to turn to contracts, the potential outcomes are far worse than what we can imagine. Apps like these seek to oversimplify the issue of consent and end up doing more harm than good. Contract-based consent can be a convenient way for courts to abdicate responsibility for remedying these harms. In a civil or criminal case, the yes that is recorded in the app may inevitably mean more than the verbal no that may be given later. Apps like these that focus on superficial clarity will actually make people less likely to come forward with accusations of sexual assault. If victims already know that their odds of being believed are low, the fear of going up in court against their own contract might create even more barriers to reporting. While already potentially facing a powerful opponent, the fact that a contract exists has a legal weight that increases the power dynamic at the expense of the victim. These apps help the accused by strengthening their case with a written component, adding to the power imbalance and preventing reporting and court remedies. Society has to reckon with the question, who do these apps really help? The victim of sexual assault or the accused?